Welcome to Prince Shorthand House. Exercise number 145, Sir Happy Singh. 120 words a minute. Ready? Start. Mr. Vice Chairman, the Union Law Minister was a distinguished member of the bar before he assumed this office, and it is my faith and belief that he would not be a party to any act which would be detrimental to the independence, integrity, and impartiality of the judiciary. He knows, however, that our judicial system suffers primarily from two distinct maladies: the malady of the delay in disposal of cases and the malady of high cost of litigation. The Supreme Court exists, the High courts also exist, but they exist for the affluent and the privileged few who can afford the luxury of expensive litigation. Unless these two maladies are removed, people's confidence in the judiciary is bound to be gradually eroded. To my mind, one of the solutions to these two maladies is the decentralization of the judicial system. I know, sir, various apprehensions have arisen in the minds of honorable members in the opposition on the questionnaire of the Law Commission, but I also know that when I was in office, numerous suggestions used to come supported by authorities as to how a restructuring of the judicial system should take place. I do not question the bona fides of the Law Commission, because going through the questionnaire, it seemed to me that they framed the questions on the basis of those suggestions, and the authorities they have cited were authorities which came mostly from other sources. I am not here to answer the questions of the Law Commission. When its report is available, I am sure the Union Law Minister would give us an opportunity to discuss this report. But, sir, the founding fathers of the Constitution did not, in my opinion, want that the Supreme Court should be an ordinary court of appeal. They had before them the model of the US Supreme Court, and it is well known that in the US Supreme Court, if 9,000 appeals are filed every year, the Supreme Court chooses to hear only 300 appeals. The position today is that the Supreme Court, in fact, has become a court of appeal, and there are more than 32,000 cases pending before the Supreme Court. No one knows how or when they would be disposed of. In my opinion, therefore, sir, the Supreme Court's jurisdiction should consist of cases involving substantial questions of constitutional law affecting the whole nation and the democratic rights of our people, deciding conflict of opinion between two or more high courts, and expressing opinions asked for by the President of India under Article 143 of the Constitution. The High Courts should mainly concern themselves with applications under Article 2 to 6 of the Constitution, and second, appeals, both civil and criminal, from the district courts. The High Courts in specified cases may have a limited original jurisdiction on the ground of proved efficiency. In my view, sir, talking from the experience of a little over 22 years on the bench, the scope of civil and criminal revision cases must be limited to serious cases of miscarriage of justice, and frivolous cases should be discouraged because they are holding up litigations unnecessarily. I know that if this scheme be ultimately adopted, similar adjustments would have to be made in the district courts with augmentation of their resources and improvement of their service conditions. Time would not permit me to go into details, but I believe that we should be careful about providing one appeal on facts and law and second appeal on points of law only to create conditions for substantial and effective justice to all litigants. Honorable members on this side of the House have rightly expressed their apprehensions about the poor litigants. There have been many schemes for legal aid to the poor. Mr. Vice Chairman, the subject is very important, but it seems it has not created interest among the members because of the fact that there might be some desire somewhere to create frustration among the people regarding the judiciary, which has been painfully carried out because Parliament and democracy are based on our constitution, and our constitution is based on three pillars, that is the legislature, the executive and the judiciary. And the judiciary is entrusted with such a job that whenever a written law is passed, it is interpreted and given the correct meaning. Whenever the executive passes an order from its subjective satisfaction, the judiciary comes forward to interpret the order and gives judgment. So, sir, if this pillar, the judiciary, is correct, the constitution goes, democracy goes, and this gives a handle to those who are taking the country towards dictatorship. That is the main basis for which I am hearing this argument from certain quarters that frustration is being created about the judiciary. Who is creating frustration? It is plan fully being done from the time of the emergency until today. Different judges have been criticized by some of the powerful ministries. Stop.